She sued me to steal a piece of my land, confident she'd win. She had no idea who she was really taking to court. The gavel's echo in that chamber was the sweetest sound I'd heard in years. Across the aisle, Margaret, the HOA president from the neighboring suburb, wore a look of pure, unquestioning victory. Her attorney leaned in, whispering final assurances. The judge looked over his glasses. Will the defendant be representing himself? I rose from my seat, calm. Your Honor, I will. Marcus Thorne, retired after 38 years in property and civil law. The color drained from the opposing counsel's face. Margaret's smirk dissolved into confusion. You see, I bought the Redwood Acres Ranch precisely to be left alone. 120 private acres, no covenants, no homeowners association. My fortress of solitude. Then Margaret arrived. She claimed her neighborhood needed an official nature path cutting straight across my northern pasture. She appeared at my cattle gate one afternoon, all faux smiles. We require a legal access easement through your property, she declared, as if presenting a bill I owed. My reply was simple. This is not your community. The answer is no. What followed was a 6-month siege. She mobilized petitions, led protest walks along my fence line, and filed bogus environmental complaints with the county. But the line was crossed the morning I found my chain cut and survey stakes pounded into my soil. You cannot negotiate with a bully who brings bolt cutters to the discussion. I upgraded to a steel gate and had a formal cease and desist delivered. Her response? She sued me. The lawsuit accused me of maliciously depriving the community and demanded $60,000 in damages. I chuckled, then went to my study. I dusted off my bar card and filed my answer, countersuing for trespass, property damage, and intentional infliction of emotional distress. The preliminary hearing was her stage. He painted me as a paranoid hermit, hostile to community spirit. Then it was my turn. I was methodical. I entered the original land grant and the current survey into evidence. Your Honor, no easement has ever existed here. This land has never been subject to any collective agreement. Then I opened my briefcase. I have security camera footage, I stated, showing the plaintiff personally trespassing on 7 separate occasions, including the night she severed my lock. The video stills were displayed. Margaret blurted, "That's not the full story. The public good was at stake." The judge peered down. "Do you dispute this is you on his property?" Her lawyer leapt up. "A good faith belief in implied access, Your Honor." Then I submitted my final exhibit, a recorded call where Margaret told a fellow board member, "I don't care about his deed. We'll pressure him until he breaks." The room fell utterly silent. The judge turned to her attorney. "Do you have any documented proof of this alleged easement?" The young man fumbled with his notes. "We are still compiling historical records." "So that's a no," he concluded, his tone flat. He ruled summarily in my favor, dismissing her case entirely. Then he upheld every one of my counterclaims. Margaret was ordered $18,000 in damages and was issued a permanent injunction forbidding her from coming within 300 yards of my border. And then the judge delivered the final blow. "Mrs. Lawson, your conduct is egregious. I am referring this matter to the county prosecutor for consideration of criminal charges." She cried out, "But I was serving my community." His reply was ice. "No, you were attempting to seize what wasn't yours. There is a legal distinction." The fallout was swift. Within a week, her own board voted her out permanently.
The criminal case ended with a guilty plea to trespass, resulting in probation and community service. I donated to settlement to a legal defense fund. Rumor has it they named a small library after her as a cautionary exhibit. If you appreciate a story where entitlement meets the cold, hard wall of the law, do me a favor, hit the like button, and for more tales of ultimate comeuppance, subscribe to Winds of Thought. Sometimes the best defense is a perfectly filed counteroffensive.